Welcome to the Teske Brief. I'm Stephen Teske, retired judge and your host. This is episode 8, and it's titled Closing the Accountability Gap. Now, in the last episode, we talked about history, about Barron versus Baltimore and what happens when power operates without accountability. And today, we talk about solutions, because identifying the problem without offering a path forward is just commentary. And this moment demands more than commentary. And that need for a fix is especially urgent for the families of Renee Good and Alex Preddy, and anyone else who believes they may have lost a loved one to the unlawful use of force by a federal law enforcement officer. Now, let me be clear, all right, before we go on any further. I'm not here to conclude that Miss Good's or Mr. Preddy's civil rights were violated, or that their deaths were definitively the result of some unlawful force. No, what we've seen so far in these synchronized videos, at least of Miss Good, we haven't gotten to Alex Preddy's episodes yet, in this series called Minneapolis Under Siege, based on these multiple angles and factual analysis, is that there is at least probable cause to raise questions, serious questions, about the shootings and the decisions that led to them. Now, those are questions for a judge and ultimately a jury to answer, not for political pundits, self-proclaimed experts on social media, or commentators on cable television. The problem, as we explored in the previous 2 episodes, is that there is currently no clear legal mechanism for those families to have their day in court when the alleged violation involves a federal officer. Now, there is a path to a jury trial when the defendant is a state or local officer. But that path effectively closes when the defendant is a federal employee acting under color of federal law. Look, folks, it's untenable and inconsistent with the principles of federalism and equal protection that a person who may have been harmed by wrongful conduct cannot access the civil courts only because the officer works for the federal government rather than the state or a locality. Look, this episode is about how that inequity can be fixed. So let's start with a simple truth. There is nothing inevitable about the accountability gap we are living with today. This is not a constitutional mystery. This is not a legal paradox. This is not a problem without tools. It is a policy failure, one that Congress has the power to fix right now. Why does this matter? Okay. And why does Section 1983, what we talked about in previous episodes, okay, matters? You see, Section 1983 is one of the most important civil rights laws ever enacted. It does one simple but powerful thing. It allows individuals to sue state and local officials who violate constitutional rights while acting under color of law. It does not criminalize police officers. It does not presume guilt. It does not abolish qualified immunity. It simply opens the courthouse door, and that door matters. Because accountability doesn't just punish misconduct, it deters it. All right. And the thing is that this asymmetry, it makes no sense. So here's the problem in plain English. If a local police officer violates your constitutional rights, you can sue under Section 1983. If a federal officer violates your constitutional rights in nearly identical circumstances, well, you're SOL, okay? Same Constitution, though, same injury, different remedy. That disparity made sense in 1871 when Congress was responding to state abuses during Reconstruction. Jim Crow laws, lynchings, things of that nature after the Civil War. But it makes far less sense in 2026 when federal officers are conducting routine policing in American cities. And it's questionable whether they're really routine, but that's being debated right now with, administrative warrants, accessing homes with no judge's signatures on those warrants. Anyway, but we'll go on. This is not federalism. This is not accountability blind spot. The straightforward fix is simply this: amend Section 1983. That's the cleanest solution. And quite frankly, it's also the simplest. Congress can amend Section 1983 to include federal officers acting under color of law, not just simply local and state officers or employees. I mean, that's it, folks. We could tell our representatives and senators that we support the Federal Accountability Act and that we want 42 U.S.C. Section 1983 amended to include 3 critical words. And the revised statute would read this: every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the United States, subjects or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. Okay? So, if we look at this, the new cause of action, no judicial intervention, no rewriting the Constitution, just parity, okay? Federal officers would be subject to the same civil accountability framework as state officers, including the same defenses, including qualified immunity. Rights without remedies are just ink on parchment. If we want a system where no official stands above the law, we have to demand that the law actually applies to everyone. Oh, come on, now, this is not radical. It's really overdue. And we're seeing it play out right now with what's going on in the streets of Minneapolis. Again, not concluding that Miss Good and Mr. Preddy's rights were definitely violated. But my goodness, folks, we've been through, at least so far this episode, the video synchronization of Miss Good's death and the shooting, that we know there's at least probable cause that merits at least an investigation. So why the Supreme Court has all but invited this? Because you might be blaming the Supreme Court, but they're not to blame. So let's be very clear. The Supreme Court did not eliminate accountability. It just simply declined to create it. Remember what I said in the last episode and in the first one, Egbert versus Bollea and related cases? The court said repeatedly that if Congress wants federal officers to be subject to civil damages remedies, Congress must say so. Okay? That is not judicial hostility. That is, quite frankly, institutional honesty. They are upholding the doctrine of separation of powers. They are saying, folks, this is not our job to do that. That's too much. We can't be going out and doing what we did in the Bivens case, all right, and creating a cause of action just out of a Supreme Court decision, because that involves too many nuances that it needs to be vetted in Congress legislatively. So the court stepped back so the legislature could step forward. So far, Congress hasn't, though. Okay, so what happens if Congress doesn't act? Well, I'm going to tell you what. Let's say, for example, they don't want to fix it. All right, let's say that, we're just not going to do it. Now, here's where things get interesting, because you see, states can do it without Congress's action. This is something that's a hidden jewel, okay, that only one person has really talked about, or is one who has brought it up. And let me talk about him in a moment. Now, here's, as I said, things get interesting. If Congress fails to act, states are not powerless. I mean, I know what some of you are thinking. Well, doesn't the Supremacy Clause prohibit states from doing this? No. And this is precisely why it mattered that we spent the last episode carefully unpacking Barron versus Baltimore, the Bill of Rights, the 10th Amendment, and the Supremacy Clause. John Barron lost his livelihood when the city of Baltimore destroyed the harbor where he fished without just compensation, even though the Fifth Amendment says that the government cannot take your property without just compensation. He quite reasonably believed he could sue the city under the Fifth Amendment, which prohibits the government from depriving a person of life, liberty, or property without due process, and from taking private property without just compensation. That seems pretty straightforward, right? Except what Barron didn't realize, And what the Supreme Court made painfully clear to them was that the Bill of Rights was originally enacted to protect citizens from the federal government, not from the state or local government. And what is the city of Baltimore? It ain't federal, folks. It's a local government. So those Bill of Rights never applied to the states, never applied to the city of Baltimore. Why? Because the country just went through a revolution. That's what made it a country. And we were in a revolution because of a strong central government called the monarchy that was abusing the colonists in the colony. So they were more afraid of the central government. So that's why they did the Bill of Rights, was to make sure in the future they protect themselves from what? The big federal government. They didn't think they would get harm from the states, but they learned later that's not the case. As unjust as the taking was, the court denied Barron relief because there was no legal remedy against the state at that time. Had it been the federal government that destroyed his livelihood, Barron would have had a cause of action. Congress eventually addressed this gap, but it took the Civil War, and they did it by enacting Section 1983 as part of that Civil Rights Act of 1871. But Congress was focused on the enemy it knew, abusive state governments during Reconstruction. What it failed to anticipate was the enemy it did not yet know, a massive armed, street-level federal law enforcement presence operating inside American cities, Portland, Chicago, Minneapolis, okay, insulated from civil accountability. All right. Look, they want to go in and do that. I'm not going to get into that. But when they do it and it leads to people's deaths, and it's questionable whether or not those were wrongful uses of force, then we got a problem. That's when it's important that we have a mechanism of accountability for federal employees. And in this case, we're talking about ICE. Now, that brings us right to the central question. If the Bill of Rights was designed to shield the people from federal power, why can't states exercise their sovereign authority to provide a remedy when federal actors violate constitutional rights within their borders? I mean, think about it. The Bill of Rights was enacted to protect who? Okay, the states from what? The federal government. Who is ICE employed with? The federal government. And who is ICE shooting? Whether it's unlawful or not, but it's questionable, and you want to get it to a jury, okay, are citizens of the state. Now, okay, so this is not really, folks, a radical idea. It was articulated decades ago by Professor Akil Reed Amar of Yale Law School, who argues that Congress does not need to finish the work of Section 1983 for accountability to exist. Yes. Under the principles of federalism, states already possess a core sovereign interest in protecting the lives and liberties of their people from any abuser of power, including the federal ones. That authority is grounded in the very structure of the Constitution. The Bill of Rights exists to restrain federal overreach. Come on. How many people out there talk about state rights? All right. Well, this is your state rights argument. Okay. So let's take a look at this. The 10th Amendment. So under the 10th Amendment, states retain the power to protect the lives, liberties, and properties of their citizens. That's your states' rights stuff, okay? When the federal government refuses or fails to provide a remedy for its own constitutional violations, states not only may act, folks, they arguably must act. Some states have already begun moving in this direction, by the way. Illinois, for example, recently enacted a law allowing victims of ICE misconduct to sue in state court. Now, the Trump administration is challenging the law, arguing that the Supremacy Clause makes federal agents untouchable. But as Professor Amar correctly points out, the Constitution's supremacy belongs to the Constitution itself, not the federal officers who violate it. If the federal government will not open the courthouse door, states have the authority, and I would argue the duty, to build one, to build that door so they can walk through it. That said, there is a right way and a wrong way to do this, though. All right? This is the only problem I think that Illinois has. And I'll be right up front, it's too specific. Illinois' effort, while well-intentioned, and I'm glad they're doing it, but I think they're going about it the wrong way and they didn't word it correctly, illustrates the risk. The statute specifically targets ICE, and that specificity is a problem. As Professor Amar warns, states cannot directly regulate the operations of a federal agency. That is the federal government's domain, all right? When a state law singles out a particular federal agency, it risks violating the Supremacy Clause by appearing to dictate federal functions. All right. Imagine the chaos if every state adopted its own agency specific rules, one for ICE, one for DEA, another one for FBI, and it goes on and on. The result would be a fragmented and unstable federal system. The solution is not to regulate the agency. The solution is to remedy the violation of any agency. So states should enact general, and I'm talking to you out there, if anyone in any state government is listening to this podcast, okay, and you're thinking about doing this, whatever you do, enact general civil rights statutes that apply to any person who violates federal constitutional rights under color of law without naming the agencies, without targeting federal functions, and without regulating federal policy. You can't do that. By keeping these laws neutral and generally applicable, states are not obstructing federal authority. They're enforcing the Constitution. Now, this approach is legally sound because it does not tell the federal government how to do its job. It simply says this: in our state, I'm in Arizona, okay, raised mostly in Georgia, born here in Arizona though, but in our state right now, if you violate a person's fundamental constitutional right, you could be held civilly accountable. We don't care if you're in the federal government. We could hold the state, we can hold a city police officer, a county police officer, but we can hold ICE, we can hold FBI, we can hold DEA, any of them. We're not going to discriminate, okay? And the state can have its own Section 1983 under its statute enumeration in their state code that says the same thing as Section 1983, but also says any federal employee, not just state and local. Now, the Bill of Rights was enacted as a shield for the people against federal power. By creating what some scholars call converse Section 1983 actions, states are not rebelling against the federal government. They are fulfilling their original constitutional role as guardians of their people's liberty. These laws do not override federal authority. They do not regulate immigration policy. They do not dictate law enforcement tactics. They say only this: if you operate here in Arizona or Illinois or Missouri, and you violate constitutional rights here in any of these states, you can be held civilly accountable here. That is not defiance. That is federalism working exactly as designed. The predictable objection, though, what I expect some people will say and why it won't work, despite your objection, but you're going to hear this argument immediately. This will make federal officers hesitant. It will endanger law enforcement. It will undermine national security. Oh, come on, folks, we've heard it before. We've already been through this with Section 1983 with state and local officers, okay? We heard it when Section 1983 was enforced right against local police. We heard it when body cameras were introduced. We heard it when the Department of Justice consent decrees were expanded. And every time the same thing happened. Professional policing adapted, training improved, public trust increased, accountability did not weaken law enforcement. It professionalized it, for God's sakes. Why? Here's the problem. Why doing nothing is the most dangerous option? Come on, let's be honest about the alternative. If Congress does nothing and states are blocked or discouraged from acting, then federal officers remain effectively insulated from civil accountability. Folks, that's not neutrality. That's a policy choice. And when leadership tells officers they are immune, when investigations are discouraged, and when remedies are unavailable, the signal is unmistakable. Aggression is safe, restraint is risky, and consequences are optional. That is not how constitutional democracies function. Come on. Look, folks, this is the moment. Every generation gets a few moments where history taps it on the shoulder. Hey, hey, all right? You don't get to ignore this. This is one of those moments. Congress does not need a commission. It does not need a study. It does not need to wait for another tragedy. It needs to restore balance. So, in closing, finally, I'm out of breath. I spent years explaining the limits of the law from the bench. This is one of those moments when the limits of the law demand action beyond the courtroom. Judges cannot make this stuff happen. We're not supposed to. It's called judicial restraint. The Supreme Court has spoken. The gap is clear. The solution is available. What remains, folks, is political will. Because rights without remedies are promises without meaning. And we already know what happens when promises replace accountability. Ladies and gentlemen, this is the Teske Brief. Thank you for being here. Be safe.